Welcome back to the London Assembly's Police and Crime Committee. We now continue our discussion on public order policing, and I would like to welcome our second panel of guests. So Jodie Beck from the Policy of Campaigns Officer from Liberty, Professor Geoff Pearson, Professor of Law at the University of Manchester, David Spencer, Head of Crime and Justice at the Policy Exchange, and Tom Southerden, Programme Director of Law and Human Rights, Amnesty International UK. Welcome, all of you, and thank you so much for coming. So I'm going to start with the questions. And this is to all of you. If I start at Jodie, ladies first, and I'll work my way down. In your opinion, how well has the Met dealt with the level of regular, large-scale protests since the 7th of October 2023? And what has it done well, and what could it do better?
Thank you. So I think from the outset, especially around October and November last year, I think what underpinned the policing of the kind of large processions throughout central London is a really troubling rhetoric from previous government ministers, particularly the previous Home Secretary, Suella Braverman. And I think that really kind of framed the way that these kind of protests were spoken about, and also placed pressure on the police to kind of take particular policing decisions. So those comments were things around hate marches, mob rule, and the policing impact is kind of emerging now in that, you know, we saw early on that the Met had to clarify what existing powers actually permit, and I think there were really good examples of where they made some really good calls and actually clarified, you know, particularly around Section 13 powers, you know, the threshold that needs to be met if a march is to be banned, when there were particular government calls to stop a march from going ahead. So I think that was a really positive example. Also kind of clarifying what is and isn't a criminal offence. And, you know, kind of if we look at the inspectorate report that came out on political impartiality just last month, that kind of said there was kind of a level of political interference into policing at that time, which undoubtedly makes policing operations difficult. The last thing just to add is that rhetoric around particular marches has not been borne out in the arrest data around these protests. You know, these are protests of hundreds of thousands of people that have gone ahead peacefully. There have been arrests, but those arrests have been very, very small. The numbers are really, really small, and the police have been using long-established public order powers to deal with those protests, rather than pulling from the more recent legislation that we've seen brought forward, which I'm sure we'll come to later on.
Okay, yes, we will indeed. And if we could just concentrate on the question, which is how well has the Met dealt with the level of regular large-scale protests? So if we can concentrate on what the Met has done. Thank you.
Generally, public order, public safety operations are very good in this country, and that includes the Met. And I think that has been reflected broadly in terms of how these large-scale protests, but other public order events, have been dealt with in the Met. I think in terms of what has been done well, these events are allowed to take place. They generally take place without major disorder. That takes some doing. Some of these events taking place, for example, in France, would not have passed off as peacefully as they have here. And I think public order commanders and advisors need to take a lot of credit for that. In terms of what could be done better, I would reflect what Jodie has said and also what Kirsty said in the previous session, which is that the messaging, the narrative from both politicians and, unfortunately, at times from some senior office, from some chief officers, and this isn't just limited to the Met, hasn't been good enough, it hasn't been precise enough, and it doesn't reflect the duties and obligations that all police forces and all police officers have in terms of human rights.
Thank you. David.
Good morning. I think, first of all, to recognise the significant challenge which these large-scale events present the Met. the Chief Inspector of Constabulary described it at some point as the brain surgery of policing, and I think that is a fair summary of just how difficult the challenge that the Met have been faced with over the last year. I think I'm the only person who's been a serving police officer on your panels this morning, so I feel qualified to say I have some sympathy for the officers that have been involved. I find it difficult to describe these, if not impossible, to describe these large-scale protests as peaceful. Huge numbers of people shouting often anti-Semitic remarks, arrests happening. It is very difficult to see how these events are peaceful. And I'm unconvinced that arrest data is the best measure of that, because, of course, predominantly that's a function of the tactical decision-making of the police. In terms of what they've done well, I would agree with the previous speaker. There has been no major disorder. There have been violent incidents, and that's obviously very difficult to deal with. But there has been no major disorder, and the public order commanders deserve significant credit for that. In terms of where things have not gone well, particularly in the early stages in October, November last year, and the Met has recognised this themselves, there should have been earlier intervention and more robust intervention to make arrests where people were clearly committing criminal offences. The Met Assistant Commissioner Twist has recognised that himself. And I think there is also a question about the public's confidence here, certainly in the research that we've done, and no doubt we'll come to this in the session. There is significant public concern about the impact of large-scale protests on the wider public. Thank you.
Yeah, and that is mentioned in your, Might is right, this is your report. Matt Twist said it himself, I believe, and it's quoted in your report. Tom.
Thank you, and thank you for having me today. I will keep it brief. My points of view are pretty similar to the first two speakers. I think the police leadership certainly have done a good job in terms of the big calls that they've had to make, in terms of facilitating these protests to go ahead, as is their duty under human rights legislation. I think they have done well in terms of resisting considerable political pressure on them. Obviously, as you heard in the previous session, and may well hear again today, all protests, these particularly, but all protests, are subject to significant political pushback from opponents of whatever demands protesters of the day are making. It happened that in this instance, that political pressure was coming from very senior, very influential figures, and the police did a good job in making clear the importance of their independence and the lawful basis on which they conduct themselves and their approach to policing these events. That said, I think there have been some examples around the edges of particular policing decisions in particular protests that may not have been correct. You heard some earlier on from Kirsty Brimelow. We appreciate these are difficult things to do and difficult things to get right, and it's important that we have sessions like this to interrogate those.
Thank you, and thank you all of you for listening to the previous session. It's encouraging. Tom, you've got such a lovely soft voice. Can I ask you, though, to pull your machine nearer you so that it can be picked up by the people pushing this out? So I'll start with you then, Tom, on my next questions and work my way down. How can the police judge whether a protest is peaceful, and under what circumstances should a protest or demonstration be prohibited under Section 13 of the Public Order Act?
Thank you. So the human rights framework for this gives us a relatively clear basis for determining what's peaceful and what's not, and what can be interfered with and not lawfully by the police. The starting point of this, as you know, is protest is a right, and so from there you have the right to do it unless interference with it can be justified. Peaceful protest is the action that attracts rights protection. Non-peaceful protest is outside of the legal framework that protects the human right to protest. When we talk about that, we talk about violence, we talk about serious damage to property. There are also constraints on what some people refer to as hate speech and incitement, speech that constitutes incitement to criminality, violence. There is also, outside of direct criminality, there is potential to restrict speech that incites violence or incites discrimination. Those are narrowly defined, I would say. The overarching position is people have a right to do this unless high thresholds are met that can justify interfering with them. So that's, is it necessary in a democratic society to do so? And the interference that the police are permitted to engage in those circumstances needs to be proportionate. And in simple terms, what that means is the minimum necessary to achieve the protection of the rights of others or the other legitimate bases for interfering. So if we're talking about flat out banning a protest, the Section 13 power that you're referring to, it would be very unusual to be in a situation where that would be proportionate in the sense of it being the minimum necessary measure to achieve the protection of the rights of others. In the lawful framework, as you heard before in the UK, that's defined as a circumstance in which the police's Section 12 and 14 powers to impose conditions or restrictions are insufficient to prevent a risk of serious violence, essentially serious damage to property. In these instances, the police have been clear that that has not arisen, and I think that was the right decision.
Okay, thank you, David.
Conscious of time, I'll probably focus on the second part of your question.
Yeah.
In relation to Section 12 or Section 13 and then Section 12 of the Public Order Act. Certainly the view that we took when we looked into this was that there is a gap between Section 12 and Section 13, and that Section 12 conditions under the Public Order Act can be applied if there is serious public disorder, serious damage to property or serious disruption to the life of the community, whereas a prohibition can only be applied if there is serious public disorder. So you could potentially have the situation whereby you apply as many conditions as you can to avoid those situations, but it still doesn't meet the threshold of serious public disorder to be able to prohibit a march. And we think that that is a gap in the legislation which should be dealt with.
Lovely, thank you. Professor Geoff.
Yeah, Tom's answered most of the points in terms of what is and what isn't peaceful. I think the key thing to reiterate is, again, that we are talking about peaceful protest being protected here. In the first session, I heard a few references to lawful protest. We don't just protect lawful protest, we protect peaceful protest. And ultimately, the more conditions that you place upon peaceful protest and the more you look to ban peaceful protest, the more banned and prohibited protests and actions within protests will be protected by the Human Rights Act. And that's a paradox that I think the police are very, very aware of. Very quickly, in terms of what peaceful does cover, it covers a gathering in which there are some individuals that want to engage in violence and disorder. That doesn't make the entire gathering peaceful if there's just a small minority there. So essentially a non-peaceful protest is a protest which is a very qualitative rather than quantitative assessment, is by its nature violent, or one which has violent intent when it starts.
Thank you. Jodie.
Just very briefly, as points I've made has been covered by Tom and Geoff, I think all I would add actually is that Section 13 carries a high threshold because it is really obviously significant to ban a protest altogether, and that any kind of reform to this area needs to be thought about very, very carefully because of the kind of impact and what we have seen elsewhere in public order powers in Section 12 and 14, for example, subject to legal challenge by Liberty currently, which I know we might come to later, is we've seen what happens when a threshold is lowered elsewhere in this legislation and the impact that has, and also how that disproportionately restricts protests that otherwise would not have been and would have been able to be carried out peacefully.
Thank you. Assembly Member Lord Bailey.
Support for the protests that we've had in London, when you ask the wider public, has been very, very low. I'm coming to David first, and I'll go to others after. Do you think that's because the public don't draw a clear enough line between disruption and violence? So we've talked this morning about violent protests, which is very easy to dismiss, and nobody wants that. But for the public, the disruption is very painful. Do you think that in the public consciousness there's not a big enough line? Start with David, please.
I'm not sure I can infer that necessarily from the work that we've done. Certainly what we found was that, or the specific questions that we asked were, would you be put off coming into your local town or city if a large-scale protest was happening? And we asked various scenarios, so if you were travelling with small children, if you were travelling with someone who was disabled, if you were going to visit a tourist attraction, go to a restaurant, those sorts of questions. And what we found was a pretty significant majority in each of those cases, and others as well, said they would not come into their local town or city if there was a large-scale protest going on. What was really interesting in the data, particularly interesting, was that particularly skewed to women versus men. Women were disproportionately much less likely to come in, and the same with older people as well. So what we can infer probably from that is that large-scale protests are likely to be impacting, certainly economically, on, for example, taking London as an example, on the economic impact of London. So that's probably what we can infer from the data.
Maybe I'll come to Professor Pearson, just you know, because people who are in favour of protests love them, you know, if it's their cause, you know, and if it's not, people hate them. That's pretty obvious. But we keep talking about violent protests, which is a particular thing, but disruption is largely what London's been suffering from. The protests have frankly been quite low level from a violence point of view. Do you think that the notion of disruption is powerful enough legally, and do you think the public make a distinction between the two?
I couldn't answer the second question. I'm not at all surprised with the findings of the research. I think disruptive but peaceful protest is protected under the Convention and under the Human Rights Act, so we need to take that into account. In terms of the issue about sort of majority of public opinion, again, we need to remember what human rights are for. Human rights were predominantly around protecting minorities. That was why the Convention came in after the atrocities in the Second World War. So I think we do need to be careful more generally about talking about majorities of public opinion and how much we should take that into account when we're making these kind of legislative decisions, if that answers your question.
It does, thank you, I appreciate that. Chair.
Thank you. It is, just going back to this though, it is really important, isn't it? I don't think we've ever seen such sustained demonstrations really in London, and it is having a massive impact on people's everyday life. It really is. Do you not think, I mean, in the polling that I've read in your report here, I mean, it says how badly it is affecting young people. Some of these recent marches, well, for the last year, young people, old people don't want to come into London. Numerous people from the Jewish community don't want to come in near or by. So at what point do you think that their human rights, if you like, as opposed to the protesters, would surface? At what point do their thoughts and their worries become as important as the rights of those that are demonstrating?
Sorry, was that a question to me?
If you want to answer.
Yes, no, absolutely. And I think this goes back to what I said a couple of questions ago, which is precision. What rights are we talking about here? I've heard rights of Londoners to go about their everyday life, rights of people to do X, Y, and Z, rights of people to make money. Well, if we actually look at the rights that are enshrined in the Human Rights Act and the Convention and other treaties, there isn't a right to go about your everyday life. We've never had constitutions and a written Bill of Rights in this country. And there is, under the Convention, a right for freedom of movement within a state, but the UK government has never signed up to that, and that goes back to 1953. So we have a piece of constitutional legislation in terms of the Human Rights Act, which essentially says these are the rights which the police, under Section 6 and Section 7 of the Human Rights Act in particular, need to particularly focus on. If we're talking about other rights which we want to exist, then we have to be much clearer in terms of the legislative framework in this country. And I don't think it's up to the police, well, it certainly isn't up to the police to do that.
Yeah, OK, that's interesting. Anybody else want to comment on that? Yes, Jodie.
I think it's really right to surface what the public think about protest. Public opinion is really complex on this. Liberty recently conducted some research with members of the public on where they stand with protest. This was a really long, deliberative process with members of the public with lots of different views from lots of different backgrounds. And what we actually found was there was overwhelming support for the right to protest in principle and a real desire to see that right protected. However, there are obviously concerns about disruption that need to be taken seriously. But what we found was that when members of the public were in conversation with protesters and people that were regularly going out to protest across a range of issues, their views actually shifted, and I think they moved to kind of a position of kind of having empathy, understanding, and again wanting to see the right to protest strengthened, and also tapping into the history of protest across London. And you know, London has a really rich history of protest, whether it's on, you know, universal suffrage, climate, you know, Section 28, But I think, again, just to kind of echo what Geoff was saying, protest is frustrating, it's disruptive, you know, whether it's, you know, being delayed, travelling somewhere, that is part of the core of protest, which is uncomfortable to sit with when protest is something that disrupts status quo. But when we're talking about what kind of limits need to be put on protest, at Liberty, we would argue that that balance has shifted further away from protesters, and that balance isn't quite there right at the moment.
Yeah, it certainly doesn't feel right at the moment. So the next question is, how has the new noise trigger in the Police Crime Sentencing and Courts Act impacted the right to protest? Do any of you have a comment on that? Tom?
I have a very limited comment, but it's quite a specific example. When this power came in, we were very concerned about it. We thought it was far too broad and open to misuse, essentially. In practice, we're yet to see, I should say, empirically, the facts of how it's playing out one way or another. The example I can give you, though, which does point to why our concerns might be valid, was that my organisation, Amnesty International, obviously we have domestic focus in the UK, but we also have an international focus. Our members are very concerned with human rights around the world. They frequently engage in protests outside embassies of foreign governments that we have found to be committing human rights abuses around the world. An incident occurred where members of ours were holding a protest outside one of those embassies, and the police went to the embassy and checked with the embassy officials whether or not the protest was being too noisy for them. Whether it was disrupting them in their work, with the strong indication that had the embassy said, yes, this is disrupting us, the protest would have been closed down. This strikes us as fundamentally unacceptable as a way of policing these things, and a very worrying indication of what the legal framework allows if the legitimate targets of a protest are to be able to determine whether or not that protest continues effectively. As it happened on that day, the embassy in question said they didn't mind, and so the protest was allowed to continue. As I say, it's a single example, and it's not something we would base a grand claim on, but it's an indication of what the current state of the law allows, and we are concerned about that.
OK. It is the case, though, isn't it? I'm sure I've read it, that when deciding on where to do these Palestinian marches, the police make sure that they do not go by the Israeli embassy. Am I right?
It's been consistently the case that they impose a Section 12, I believe it is, condition that prevents those marches from going.
Well, I would think that was right. Do you think that's right?
Well, as I say, instances like this are very subject to the factual realities of the particular protest. We have been concerned about the use of the Section 12 powers on the Palestine protests. We haven't vocally opposed the decision to prevent them going near the embassy. We do say that, in general, embassies are legitimate places for protesters to assemble and to voice their opposition to the policies of the government that is represented by that embassy. A Section 12 restriction on that basis would need to be based on strong evidence that there really was a serious risk. I haven't seen the police rationale for that. One of the things that many of your panellists have said is that the police could do a better job of communicating the basis on which they make their decisions, and I think that's an example of where they could do a better job.
Okay, thank you. Geoff?
The police's duty under Section 6 of the Human Rights Act is relatively clear. They have a duty to facilitate effective protest. And what that means in a lot of senses is that the protest should be within sight and sound of the target. Now, that doesn't necessarily mean that you have to be on the doorstep of an embassy, but it does mean that if, for example, your target was the Israeli assembly, there must be some way in which you can try and get your message heard to them. Now, that may be through television, it may be through social media. So the duties on the police in that respect are quite clear. Now, to bring it back to the noise, if you were to tell a protest that it couldn't make noise that was heard effectively by anybody, the police wouldn't be doing their duty under Section 6 of the Human Rights Act. They wouldn't be facilitating effective protest.
Thank you. David?
My reflection listening to this is how sterile it all sounds. I work for an organisation that has been the target on several occasions now. And I have to say it is a deeply unpleasant experience. It is not something that we just sit through and think, oh, well, this is all fine. What's going on outside and in our office building? We have had paint thrown over our building, and the receptionist on that occasion was terrified, and that is the right word to use, terrified that the protesters were going to throw paint over her. We've had smoke bombs let off, which set the smoke alarms or the fire alarms off, which meant the building had to be evacuated. We have had the amount of noise that goes on for hours and hours prevents not just our work, but other people in the building, the cafe opposite. This is the idea that we are all just supposed to just tolerate this as the targets seems to me, whatever the legal position, which I appreciate I'm not commenting on here, seems to me absolutely remarkable. And I'd go back to the word that one of my colleagues used. She was terrified by what was happening.
Yeah, and I think we should remember that. I'm going to leave my next question because I want to make sure my colleagues all get to theirs. So I'll go now to Assembly Member Garbutt.
Thank you for your contributions, panel. So I'll be starting with Jodie and then working along. But I just wondered if you could speak to, obviously, Liberty have done a lot of work on this, but the more than minor definition of serious disruption. Should those charged under the more than minor definition of serious disruption have their charges quashed if the appeal against the regulations is successful, and why? And if you could just speak to a bit about your work you've done on that. Thanks.
Yeah, thank you for that question. The short answer to the final bit of that is yes. People who've been charged under those, under the more than minor definition should absolutely have their charges dropped. Just to speak about the case more broadly, for Liberty, this is really a case about the rule of law. It's about governments behaving responsibly and within the bounds of the law. And as I think some colleagues on the panel, the previous panel said, the passage of these regulations, which lowered the threshold for the definition of serious disruption to more than minor, they were pushed through via secondary legislation with no scrutiny after they had already been voted out in primary legislation. And it was the first time any government has ever done that, introducing something through the back door after it's already been voted out by a cross-party majority in the House of Lords. So earlier this year, the court found that the regulations were unlawful on 2 grounds. The first was that the regulations went beyond the enabling power that the Home Secretary did have to clarify the definition of serious disruption, because rather than clarifying the definition, which would maybe involve something like providing examples in the guidance of where something would meet the threshold of serious disruption, the threshold itself was lowered to more than minor. So, yeah, the regulations went beyond that enabling power. But also the second ground that we won on at that point was that the regulations are unlawful because they were pushed through as a result of an unfair and narrow consultation process. So there was a very short backdoor consultation solely with police leaders, which is obviously narrow because although the police are the people that are using these powers and enacting these powers, people are being subject to them as a result of that, and there needed to be, you know, part of a fair consultation is consulting with all affected parties. But if we kind of look at, you know, the evidence base for lowering that threshold is simply not strong enough. The policing bodies that were spoken to by the Home Secretary at the time, again, spoke about clarity rather than a lowering of the threshold, which it's important to separate that those are 2 very different things. But also, the regulations emerged as a result of slow-walking protests, and around the time before the regulations were introduced, if you look at any kind of Met press release at the time about, you know, them reporting the conditions that they'd imposed in slow walking protests. I have a quote here from the 156 slow marches that have taken place. 125 Section 12 conditions have been imposed. So that's before the changing of the definition. So that suggests that the existing powers under Section 12 with that definition before it was changed was actually sufficient for the police to actually impose conditions on these actions. There are also powers elsewhere that the police were using to tackle this, such as Section 7 of the Public Order Act 2023, which introduced an offence of interfering with the use or operation of key national infrastructure. So again, I think what that suggests is that there's a very, very cluttered legal landscape for the policing of protest, and actually what happens when governments reach for new tools is they're simply adding to that very complex web of legislation when there is sufficient evidence to suggest that the police are using the powers they had before.
Yeah, I've carried out research with police for over 25 years now, a lot of it embedded within police patrols and police operations. The police struggle with the amount of powers that they are given and the amount of laws that they are asked to impose. It's impossible for them to recall all of these and to be able to understand all of these in the kind of blink of an eye decision-making scenarios in which they find themselves, and I would just support from my research that it is clarity that that all the police commanders I speak to were after and are after, rather than a lowering of the threshold. In terms of the more than minor, whether is that compatible with our human rights obligations on a European level? I don't think it is. And I don't think it's compatible with the Human Rights Act, which is, after all, constitutional legislation.
Well, I'm delighted. This question gives me the opportunity to agree with Liberty and Professor Pearson, so I'm very grateful. So 2 things. First of all, the legislation. There is no doubt that the legal regime is, I think, cluttered, one of the other panel members said. And it is hugely challenging. I remember about 20 years ago when I joined the police, if you knew the Theft Act and the Offences Against the Person Act, assaults, then you probably knew about 80% of everything you were going to turn up to. And that has changed massively in the last 2 decades. So, you know, theft and assaults are less than half of what you would turn up to. So, you know, that's different to protest. But it's just an example of the legal regime, and particularly on protest, is very, very difficult to deal with. And then on the minor disruption point, our view is that certainly elements of the case that Liberty has brought is correct. As has already been said this morning, Parliament rejected this as primary legislation. The government then brought it in as secondary legislation. Our view is that that is not the right way to have gone about things. We don't necessarily agree with everything that, unsurprisingly, that Liberty has said in their case, but certainly on that core point, then we are aligned with their view entirely.
I will keep it brief because we're all in agreement on this question. I just thought I'd emphasise that what was done with those regulations is to attempt to define what the word serious disruption means. So serious disruption is the legislative standard, and then regulations like this were, at least in theory, there to give the police a better understanding of what was meant by that. What it's ended up doing is defining serious disruption in the way, and the court has found this, in a way that is not the natural and ordinary meaning of the word serious. Right? So we have a situation where a legal standard has been given a definition that is not the natural and ordinary meaning that any of us would, and certainly a police officer seeking to implement it, would naturally and ordinarily understand it to be. This is a chronic recipe for confusion. It's a chronic recipe for misuse of the powers, well-intentioned or otherwise. The court has been clear that that is the inevitable consequence of being in this situation. It needs to be resolved. I share Geoff's view that this would also separately be a breach of the human rights standards, but even without that level of protection, we're in basically a nonsensical situation that needs to be solved.
Thanks. I just have a brief follow-up just for Jodie. Just on the new legislation, I just wondered if you could speak briefly to the impact of the change that I asked earlier about the national infrastructure, so the conspiracy to disrupt infrastructure, and that we're seeing people being arrested for kind of, attending workshops and things. I just wondered if you could briefly speak to your view on that. Yeah,
so whenever any offence is created, there's always the possibility of, being convicted or found in suspicion of conspiracy to commit that offence. So when we expand the category of protest-related offence, which we've seen in recent years, which includes bringing tactics that have been used throughout history into the criminal law, that inevitably has an impact on intelligence gathering. And what that means in a protest context is, are police attending organising meetings by protesters? Are calls being intercepted? And I know we've seen that in the news being spoken about much more. So I think it actually connects to our concerns about the legislation as a whole, in that what we have seen because of these new offences is a real essentially creating a hostile environment for protest, and people who organise protest and organise with community members about what the risks are to being able to organise privately, essentially, and without fear of people joining that perhaps don't are there to gather intelligence. And there are a lot of learnings here, actually, particularly in the context of the Met, both from a protest context. If we think about the undercover policing inquiry that's going on at the moment, the roots of that were in activist movements, and that that needs to be watched carefully, and the learnings need to be taken from that. But also, more broadly, recent challenges to other policing practices, policing surveillance practices in recent years, like the gangs matrix, for example, which had one of the conclusions from that challenge was that there were so many young black men predominantly on there that hadn't ever committed a criminal offence but were being subject to intelligence gathering because of the setup of that matrix. So I think there are lots of really important learnings here, particularly for the Met.
Thank you. Lord Bailey, very, very briefly.
I'm going to come to you so you can jump in. And I'm going to come to the Professor as well. So you've talked about a cluttered landscape, I think legal landscape for the police. I think our former panel would agree with that. But do you think that some of this cluttering has come as a response to new protesting techniques and new levels of organisation? So you have protest groups who now have legal counsel who tell them how to cause the most disruption with the lowest legal sort of outcome, as it were, for them personally. You have protest groups who are throwing paint in some places, gluing to have new tactics. Do you think that some of this cluttering is in a response to these progressions? I'll start with if I go David and then Professor.
I suspect there are probably others who are better qualified than I to answer that. My suspicion is yes. What we see is new techniques coming out, and then the police and the law trying to catch up and respond to it. So my suspicion is yes, but there are others who are probably sort of better legally qualified to answer that. The point I did want to come back on the minor point, which Assembly Member Garbett asked, was that the current situation around the legal regime here, primary legislation turned down, secondary legislation brought in, divisional court decision as a result of Liberty's case. The police have been relying on this secondary legislation since it came in, and it's been a significant part of how they have dealt with protest over the last year and a bit. So the current situation where the police find themselves, this is hugely challenging. I was actually in Scotland Yard when the Divisional Court handed down the decision, and I can say, without going into too much detail in terms of who the people were, there was some. That poses an interesting challenge for us. Let's say this is really a very difficult situation for the Met to find themselves in. Again, a very difficult, cluttered legal regime.
So I've not been embedded in protest communities, so I can't answer this with any absolute clarity. But yeah, it wouldn't surprise me at all that certain tactics, that the clutter and the new laws were a response to new tactics and new types of organisation in protest whatsoever. I think the question is whether the old laws would have been sufficient to respond to those new tactics and those new organisations. And broadly, I feel that the old laws, for example, the old laws in terms of criminal damage, the Highways Act, would have been sufficient. I don't think a lot of the new laws, there may be some exceptions, take us beyond that in terms of enabling a criminal justice response to those evolving tactics, if that makes sense.
Jodie, maybe I'll ask you the same question because you seem to have a closer relationship with the actual groups on the ground. Briefly.
Yeah, it's a really good question. I would kind of gently dispute that these are new tactics. I think we've certainly seen a re-emergence of tactics that have been used throughout history. A lot of people talk about the suffragettes, that's one example, but taking locking on, for example, which is now a criminal offence, has been used repeatedly by a range of movements throughout history. And I think what is perhaps missed when when presented with seemingly a new problem, it can be very easy to resort to a new law, a new power. And I don't quite think that we've seen the thinking and maybe the evidence gathering happening before reaching for new legislation here. Good lawmaking should have that future-proofing element to it, right? And I think if we look at the origins of the Police Crime Sentencing and Courts Act and very quickly after that, the Public Order Act, that was created in response to very specific movement groups, particularly those that are organising on the climate, and that just isn't good lawmaking. We need to do the thinking to make sure that this is not going to be disproportionately used towards one group over another, and that it won't be essentially that it won't be impacting the right to protest full stop, but actually that's what we've seen happen. And I think the last point is the origins of the Police Crime Sentencing and Courts Act, for example. Her Majesty's Inspectorate of Constabulary were given some of the proposals that later made it into that Act to review. And it makes for really interesting reading, that report, because lots of police, members of the police, particularly senior police officers, really contested a lot of those proposals, particularly serious disruption prevention orders, for example, which I'm sure we'll come to. But that's not reflected in the legislative landscape now.
Okay, thank you.
We can't leave Tom out because Tom,
Tom,
you must be
Just
very quick.
Very briefly, I wanted to echo Jodie's point that I don't think it's fair to say that these are new protest tactics that's spurring this. Things like tunnelling. I was born in the early 80s, so early 90s, you'll remember the anti-road protesters, people were tunnelling, people were climbing trees. This is long-standing tactics that was the subject of political decisions to criminalise. So what was driving these new laws is less new tactics and more a political decision to take a different approach to them. Going back to something in the previous question very briefly, I don't want to disagree with David's experience of being the subject of protest. I did want to put on record that my organisation is also regularly subject to protesters outside our offices. It is not inherent in that happening, that the kind of very difficult circumstances that David describes will always be the case and will always be the experience of their staff.
Yeah, maybe when I said new tactics, I should have talked about the scale of the tactics, the regularity of the tactics, because nothing is new under the sun normally. But it's the scale at which these things have done. I'm particularly interested in the disruption. The disruption in and of itself could be economically damaging and actually very intimidating as well. That's why I posed the question. But thank you.
I take the point. I think I would just add that often there is a demand when dealing with a new protest movement or a new social phenomenon more generally, for a new law to be passed. Politicians need to be seen to be doing something, and we've had the point made that actually most of the time the pre-existing legal regime was sufficient. Yep. In this instance, we've now got criminal offences and other protest regulations that really cover the same ground in multiple different ways. So you have the kind of disruption that you're talking about has been criminalised or restricted
on that point,
in three or four different legal
on that
frameworks.
point, we could agree. Back to you, Chair.
Thank you, and I think we've picked that up earlier as well. Thank you. Assemblymember Roberts.
Thank you. We may have covered off a certain amount of this already, but serious disruption prevention orders, do you think that they can be effective in preventing disorder at protests and marches and rallies and such like? Anybody who wishes to have a...
I've done absolutely loads of research on football banning orders. They were brought in the Public Order Act 1986, in fact. And they were absolutely, almost completely useless for the first 10 years of their operation, because there wasn't the policing and intelligence frameworks to allow them to work. Then they started to be used rather indiscriminately and quite questionably, and I would argue that it's only in the last 10 years or so that we actually see football banning orders being quite effective and proportionate in terms of the effect they have. But that requires the UK Football Policing Unit, that requires dedicated football officers, operational football officers, absolutely loads of them across the country and at each club that are specially trained and expert in their job. SDPOs, if you read the legislation, they borrow very, very heavily from football banning orders. But ultimately they will need that framework if they are to be effective. And as far as I see it at the moment, that framework doesn't exist.
Thank you. Tom?
I thought I should make clear for those that don't know the detail of this, SDPOs, although they are enforced, the reality is they haven't yet been used, so we're speaking in hypotheticals.
Yeah.
The reason for that is that you need to have at least 2 convictions for a protest-related offence to get one. They were only brought into force in April this year, so there just hasn't been the time for people to rack up or be in the zone of potentially having one. But we may well be moving into that period shortly. We are, in principle, very concerned about them. I mean, I take Professor Pearson's point about football banning orders more generally. The underlying issue there, though, is that we're talking about the exercise of fundamental human rights in relation to protest, as opposed to the right to attend a football match. We've had some... No, you don't agree?
Sorry, very, very briefly, if I may, because this was also mentioned by Matt Parr, who said, quite correctly, there is no right to attend a football match, and there isn't. Football matches are put on by private organisations, they're not bound by the Human Rights Act. However, if a football match is prevented by a public authority, such as a police force, which said, I am not going to actually fund the officers for this to take place safely, they would have to take into account the Article 10 and Article 11 rights of the fans looking to get together. Now, that is not to say that those rights are at the same level as the Article 10 and Article 11 rights of protesters protesting against serious ecological or democratic issues. But I would push back against the idea that there are no human rights implications at all relating to football crowd gatherings. Sorry, I have interrupted you there, Tom. My apologies.
It's an interesting point. I suppose I was getting at the not the event of a football match going ahead, but a decision to ban a particular individual from participating in them. I take your point that there is a freedom of association point there, but as you say, it's does not engage the same factors as a political protest situation. Because of that, because of its the importance of political protests and how highly that is protected within the human rights framework, it's very hard for us to see how an SDPO could be justified as proportionate and necessary. What they are, the scheme of the Act is quite clear that they would be used to ban somebody from participating in a protest, flat out, and also ban somebody from communicating with others using the internet, using their phone. It would require, as we've heard, very extensive surveillance powers. It would require people to hand over their phone and their WhatsApp and whatever else, or access at least to them, to the police, to either spot check or regularly check whether or not they were complying with these orders. These are all very major intrusions into very fundamental political rights that we're talking about here. So we are yet to see, but we're very concerned about how this seems structured to pan out.
Thank you. Jodie.
I'll just briefly add to that. So the threshold, as Tom has said, is you have to have been convicted of 2 protest-related offences, which might read on paper as quite a high threshold, but actually because we have seen the category of protest-related offences expanded so significantly in recent years, it's actually not a very high threshold. You know, if we think about how particular offences are drafted, we've spoken a lot about the more than minor definition of serious disruption, which means effectively breaching a more than minor condition. It is really quite easy. The risk of protesters being given one of these orders is very significant, and with such a serious power that would ban named individuals from protesting and then subject them to a range of requirements, that needs to be kind of thought about really sensitively and carefully.
Thank you. David.
This isn't something that we've looked into because it's so early. I guess my only question, if 2 isn't the right number, then what is 3, 4, 10, 20, 50? Like, what is the right threshold? I realise you're the ones asking the questions.
No.
That would be my only observation.
I mean, it's the difficulty inherent in trying to enforce these orders, the fact that at a football stadium, you have a discrete and defined area which people will be in, and it's a fairly static group, and they are bound by certain behaviours. So covering of faces, for example. You won't be able to spot the people in various protests. People are not asked to give over their mobile phone details and such like. It's a different milieu from football and protests. It's a different thing entirely, surely.
To a certain extent, there is usually, well, quite often for a protest, as there is for football, there is a focal point that people are going to, but they will take a route to get there, and being on that route will often be as significant as the focal point of the protest. And at football, to just go back to my first answer, the reason that it works in terms of enforcement, whatever the questions are about the sort of human rights elements of it, is because you've got that framework in place, and you've got operational football officers and dedicated football officers who've been in post, who have considerable expertise and who know the people who are banned, and that's how it works. And I'm not sure that is in place at the moment, and particularly because with protests, you have people that maybe go along to 1 or 2 protests every 10 years. In terms of the how many is enough, my concern with SDPOs is that actually the number would come down, as it did in football. You don't need to have any conviction to be given a football banning order, so the concern is it would go down.
Yeah. Okay.
Can I just briefly add that was actually the original proposal. That threshold has only been imposed because of cross-party concern that actually people who hadn't even attended a protest before could be subject to a banning order. So the model for this has actually evolved significantly already. Clearly more thought needs to be had about that.
Okay, that's lovely. Thank you very much.
Thank you. We have 3 more questions left, so I want to make sure everybody gets theirs in. So, Assembly Member Lord Bailey.
I'm going to come to Professor Pearson. Across the 23-24 Football League season, the Met was only able to recoup around 2.4 million in costs out of a total expense of 23.9 million. Should London's football clubs be making a greater contribution to policing football matches? And in addition to that, how could the Met reduce its presence at football matches and avoid public order disorder risk? And the other thing, before you answer, when people talk about this subject, do they take into account that the people attending the football match are taxpayers? So they would argue some of their taxpaying fees, and also that football is a significant contributor to our public bottom line, our public economy, in a way that maybe a protest isn't. If you, I mean, you're comparing apples and oranges here. So when you answer, could you take those into account?
Yeah. So in terms of the final point, yeah, absolutely. The tax income that's generated from football at all levels, but also not just the financial contribution to communities, but what football clubs bring to the communities is an area there's been a lot of research in terms of community identity and happiness, and that should certainly be taken into account when we have these conversations. In terms of whether football clubs in London and across the country should be paying more, there's certainly an argument that Premier League clubs in particular would be able to find money somewhere if they shifted things around, given a few years, to make that contribution. The concern from the English Football League, and I think it's a valid one, is that actually Football League clubs are very much, if they are breaking even, then they are doing a very good job, and additional pressures in terms of having to play for police, which they would say, well, some of this is already coming out, we're paying in taxes, may well drive some clubs to the wall. In terms of your middle question, which was how potentially can the Metropolitan Police maybe not spend as much money, I mean, I think that this is something that we've been looking into for the last 10, 15, 20 years. And ultimately, more police officers in football doesn't tend to mean more effective football operations in terms of public order. What we tend to see in terms of how football is traditionally policed is that we will have PSUs, so 3 serials of officers in 3 vans that will be that will stand around in groups, essentially acting as a deterrent or waiting to react to disorder. Now, there is a project which is going on nationally, but also in the Met, called the Enable Project. And at Brentford last season, the dedicated football officer there bought in heavily to this, and for 16 matches of the season, they trialled a new system that instead of bringing in public order trained officers from these PSU units, they would have a single PSU unit when they could, which was made up of operational football officers. So officers that were specifically trained in managing football crowds and in terms of identifying risk, but also being proactive. And what they found was that, first of all, over those 16 matches, they were able to prevent the unnecessary extraction of 499 officers. That was a figure I was given, so if it's wrong, please don't blame me, over those 16 matches. So those were officers which, to bring your point in the previous session, could have been investigating murders, meant they could stay in their normal jobs. In terms of the outcomes, there was no increase in public order, but there was an increase in terms of crime detections at those matches, which indicated that the officers were doing more. So actually the taxpayer was getting more for less. That project is ongoing. It is being rolled out at different clubs in London, and there is an invitation subject to the DFO at that operation accepting it if any member of the London Assembly would like to attend and see how that potentially works. That offer is out there. I'm passing that on. That's not my offer.
Thank you. I think that's a very comprehensive answer to my question. Thank you, Chair.
Thank you. Thank you very much. Assembly Member Best.
Thank you. I wanted to ask questions in relation to the powers for stop and search for objects related to protest without suspicion, and perhaps start with you, Jodie, and think whether that is a good power and for the police to be able to use.
Thank you for that question. So we at Liberty, we oppose the use of stop and search in a protest-specific context, and when these powers were being introduced into Parliament, we worked with parliamentarians to amend the Act so they didn't feature. We were obviously unsuccessful. They came into force last December. The data that we have so far, which is limited, so current stop and search data only runs up until the end of March this year, shows that these powers aren't being used very much at all at the moment. So there were only 35 individual suspicion-based searches for items related to protest in that period between December and March 2024. And I think one of the main issues with using stop and search in this context is because the prohibited items list for a protest-related offence is never-ending, so that could include a whole host of very innocuous objects. And what we've seen to date, actually, is where that power has been used, it's captured people who are going to protest peacefully. It's captured people who are just going about their daily lives. So we can look at, for example, arrests at Royal Ascot for carrying nail glue. Again, just showing that a range of everyday items are being captured in this list. But I'd also kind of question if this is in line with the Met strategy at the moment. You know, we've seen this new Met for London plan come forward, and part of that is taking a more precise approach to the use of stop and search. And this never-ending list of prohibited objects in a protest-related context doesn't lend itself to precision, because it concerns things that we might well be carrying unrelated to protest. It concerns things that kind of tie that you would use to keep your placards together if you are going protesting. So I'd really query the use of that power at all. And just lastly, this was perhaps one of the parts of the recent legislation that received the most opposition from across all corners of politics. You know, we had ex-Prime Minister Theresa May coming out and saying, look, we need to think very carefully about expanding stop and search in this context. We had a range of former chief police officers kind of saying the same. And so, yeah, it's certainly a real big area of concern for us at Liberty.
Thanks. You did start by saying there's only been 35 cases, so would that show that it isn't being used over exuberantly by police?
I would think about it, I would characterise that a little bit differently. I think I would, the way that I would view a low use of the power is that there isn't sufficient reason for it to exist. And I think in the context of, you know, as many people on the panel have said, a very cluttered legislative landscape for protest, that's even more troubling, because there are just the sheer amount of powers that the police can use in a protest context means that we should really deeply question whether we need more. And kind of, I certainly think that, yeah, Liberty absolutely has concerns about stop and search across the board, but to kind of keep it in the protest context, the police can use stop and search for other reasons if it meets the kind of, you know, the criteria for using it, if there's suspicion of serious violence, for example. So that power is still there. We just certainly don't believe it should be extended to a protest-specific context.
Thanks. Does anybody else on the panel want to come in on it?
Briefly.
Just very briefly, I would echo everything Jodie said. I think from our perspective, this goes back to this underlying point about protest and the attitude to protest as opposed to other things. Suspicionless stop and search is, as this panel I'm sure is very aware, is a very controversial power. It's subject to lots of concern across society, and I'm sure this panel has dealt with that over the years. The justification for it is that it's used in the context of a risk of very serious violence. Now that is, whatever else you may think about suspicionless stop and search, that's the bar on which it can be justified. That is no longer the case, because except when it comes to protest, because protest has become the only scenario outside of very serious violence where the police can now use suspicionless stop and search. And we say that that's the wrong approach to the legal framework around protest itself.
Thanks. And Jodie, I just had one follow-up, if that's okay, because one thing that plays on my mind throughout this discussion, especially from hearing yourself and perhaps Tom to a degree, is when you're talking about protecting the right of protest and protest, do you see it through the prism of all protest? Because it's very easy, I think, to talk about certain protests, but the police have to be apolitical. So, for example, this October, Tommy Robinson will be holding a march in London. For example, we have anti-abortion protests. Now, when it comes to police, it is up to them to treat all protests fairly and justly and have an apolitical stance on that. Is that the prism through which you are talking about these rights and the research you talked about, is that the prism through which you see that?
In the research we conducted, we spoke about a range of... In fact, we didn't even present a particular case. It was the people involved in those groups that brought a range of issues that they wanted to protest about, whether it was climate, whether it was attending a Palestine Solidarity March, whether it was a myriad of issues. We certainly work across a range of issues. I can't say that we would be commenting substantively on the contents of a range of protests, but for us, the overarching point is the right to protest should be protected, and I think we'd certainly also take the view that some protests have been policed in a different way to others, or rather rhetoric surrounding particular protests has shaped the policing approach to those protests as well. So I think it is a slightly different picture.
I think, if I may, very quickly, just to add to that, this is one of the problems that we have in terms of just viewing this through the lens of protest rather than viewing it through the lens of peaceful assembly, because we get into situations where we have, for example, the Sarah Everard vigil, which was not meant to be a protest, was but still had those human rights protections. Gatherings for the Queen's funeral cortege, the Notting Hill Carnival. These all trigger, to varying extents, Article 11 protections in terms of peaceful assembly. And we start to get into trouble when we try and pick out protests from the others. And if I can give a very quick example, football officers trying to deal with fans that are marching to the ground, setting off pyrotechnics. If part of that march is a protest, for example, against ticket prices, and they set off that pyrotechnic, they can be arrested under protest legislation. But if they just set it off because they're going to the football match, they can't be arrested. That's when if the legislation comes through. And that's really challenging for public order officers that have to do, of course, this range of events.
Okay, thank you very much. Last but by no means least, we have Assembly Member McCartney, but we have only 5 minutes, so can we bear that in mind? Thank you.
I will do. Thank you. Section 11 of the Public Order Act 1986 says that the police should be given 6 clear days' notice of any intended protest. Can I ask, is that working well? Or has there been any arguments put forward about extending that notice so the Met or the police forces can better arrange their resources, for example? Or is that not something that you've discussed? I'm just going to start with Tom and work down the panel if I can.
Given that we've got 5 minutes, we've got a limited answer to this. So that relates specifically to marches, I would say, and I would also highlight that it only applies to the extent that it's reasonably possible to give that kind of notice. So it does allow for what's referred to as spontaneous assemblies from time to time. We say that that's an important distinction to make. Without that, you're in a situation where you have essentially the legal framework being that the police are able to give permission or not for a public demonstration. And the human rights framework is structured that you have the right to do it subject to lawful and proportionate restrictions and so on. So the arrangements as they currently stand seem to us, broadly speaking, acceptable on that front. I'm aware, I'm sure David will be about to tell you about, there are ideas around there for extending that, and we do not support those ideas.
Thank you. David.
Not wishing to be entirely predictable, Tom is entirely correct. So we recommended that England and Wales should replicate what happens in Northern Ireland, which is rather than 6 days, it's 28 days. And the basis for that is the amount of work that is necessary to happen within policing and elsewhere to be able to put the resourcing together without substantially negatively impacting policing, for example, in the rest of London, in your constituencies, is substantial, and 6 days just isn't enough to do that.
There will be some protests which 28 days or longer, or even 2 weeks isn't, that opportunity may have gone. So that's something to take into account. In terms of how it works at the moment, generally I think it works well, and it might even work well in terms of the 28-day proposal, as long as Gold Commanders have the independence to be able to do that human rights balancing act. And I think that's one of the reasons it has to date worked well, is that they've done that proportionate response in terms of not banning marchers willy-nilly. So I think that's something positive. My concern is when you start to have political pressure upon commanders that are making those decisions, and of course the longer they have to make those decisions and put that in place, I think the higher the risks are that we won't get a proportionate human rights decision.
Thank you. Jodie.
I would just echo the comments made by Tom. At Liberty, we wouldn't support the extension of that time period. It's really important to protect the right to assemble spontaneously.
Sorry, apologies. To come back on the Northern Ireland comparison, it's important to understand that what we're talking about here is an interference with protest rights that could potentially be justified, and the particular circumstances of Northern Ireland are such, when we're talking about marches, are such that the framework that has been put in place there is, broadly speaking, in compliance with human rights obligations. That's in the very particular set of circumstances that does not pertain in London, does not pertain in England and Wales more generally.
Yeah, thank you. Thank you, Chair.
It's very difficult, isn't it? Because public will say that they have got human rights, and we've heard what you've all said today, and it would appear it's not quite as simple as that. But I hear all the time people feel that they can't come into London for various protests. But thank you so much. This panel and the panel before, I think my colleagues will all agree it's been so informative. So we're really grateful for your time. Thank you. So thank you, guests, for attending this morning and for your answers to all our questions. Can I ask the committee to note the report and the discussion? And can we also delegate authority to me as chairman in consultation with party group lead members to agree any output arising from the meeting?